When the creators of the United States Constitution had finished their work, they presented a relatively brief document to the nation that outlined a framework and procedures of the proposed new government and set limits on how much power that government would have. As the framers developed the Constitution, they based much of its direction on several basic foundational principles that have kept the Constitution relevant even as the nation evolved. One of these principles is popular sovereignty, which ensures that all power ultimately rests in the hands of the people. Because people give the government its power, it can only function with the consent of the people. Along the same lines, the principle of limited government states that government can only do things that the people give it the authority to do. Government cannot invade all areas of its citizens' lives. The concept of separation of powers is another very important foundational principle for our government. Based on this principle, the Constitution divided the power of the national government between the legislative branch, made up of the Congress, the executive branch, which is the President, and the judicial branch, which consists of the Supreme and federal courts.
The accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, may be justly pronounced the very definition of tyranny. James Madison, Federalist No. 47, 1788.
With the power of the government separated, the Constitution's principle of checks and balances gives the three governmental branches the power to restrain the other, preventing any one entity from gaining absolute power over the country. An example of the checks and balance system in action is the President's power to veto any law the Congress passes. The Congress can also override the veto if 2/3 of the House and Senate vote to do so. The principle of judicial review is also part of the checks and balance system. With this principle, the Supreme Court, federal courts, and some state courts have the power to declare an action unconstitutional, making it illegal. The Constitution does not specifically outline judicial review, but the Supreme Court established the power in the case of Marbury v. Madison in 1803. Another basic principle that the Constitution was designed around is the system of federalism, a system that divides power between the national government and state or regional governments. For the constitutional framers, the goal of this principle was to develop a national government that deals with issues that affect the nation as a whole, and leave state and local governments the power to deal with matters of local concern. They also wanted to prevent the national government from being able to get absolute tyrannical control, while preventing problems arising from a weak confederation of independent states.
Federalism furnishes the means of uniting commonwealths into one nation under one national government without extinguishing their separate administrations, legislatures, and local patriotisms. James Bryce, 1888.
As they created the U.S. Constitution, its framers were careful to ensure this document would lead to a more perfect union. In its original form, the Constitution included a preamble and 7 articles. The preamble was essentially the mission statement for this ambitious new nation, outlining the broad purposes the Constitution was designed to address.
We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Preamble of the U.S. Constitution, 1787.
Article 1, perhaps the most inclusive, establishes the rules and requirements for the legislative branch. It states that the House of Representatives will be completely re-elected every 4 years, and calls for the number of delegates per state to be based on the state's population. Article 1 also states that members of the Senate must be elected every 6 years, and that each state will have 2 senators. Section 8 of Article 1 broadly defines the powers of Congress, including the power to tax, borrow, coin money, regulate commerce, grant patents and copyrights, establish a military, and declare war. It also includes the important elastic clause, which gives Congress the implied powers to do that which is necessary and proper for carrying out its duties. Several key individual rights are also established in Article 1. Here, the government is prohibited from denying citizens a writ of habeas corpus, which prevents imprisonment without being charged. It prevents the government from issuing bills of attainder, which are legislative acts that hold a person responsible for a crime without a trial. It also prevents the government from establishing ex post facto laws, or laws that make an action criminal after they have occurred. Article 2 of the Constitution establishes rules for the executive branch. It states that the President and Vice President are required to be elected every 4 years by an electoral college. It also establishes that the President serves as Commander-in-Chief of the military and as the nation's chief diplomat. It gives him the power to appoint federal judges, grant reprieves and pardons, and make treaties. And the third section outlines how civil officers may be removed from office by impeachment. The federal judiciary is outlined in Article 3. It creates the Supreme Court and grants it original and appellate jurisdiction. It also allows all federal judges to serve for life and guarantees a person accused of a federal crime the right to a jury trial. Article 4 outlines the relationship between the states. It requires each state to give full faith and credit to the public acts, records, and judicial proceedings of other states, and gives full privileges and immunities to the citizens of each state. The rules for creating new states are also outlined here. The 5th article outlines how amendments to the Constitution can be made, stating that a 2/3 vote of both houses of Congress or a 2/3 vote at a constitutional convention are required. Since 1787, the Constitution has been amended 27 times. Because the U.S. government under the Articles of Confederation had debts, Article 6 outlines the transfer of this debt to the new government. It also contains the famous Supremacy Clause, establishing the Constitution as the supreme law.
This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land. Article 6, Section 2 of the United States Constitution, 1787.
The method for ratifying the Constitution was established in Article 7, requiring an approval of 9 of the 13 states. With its radical ideas, the Constitution answered the weaknesses of the Articles of Confederation by establishing a strong central government that had restrained authority. It also allowed states to have power within their borders. But many leaders believed the Constitution should go further to ensure individual and civil liberties. It was not long before these leaders would establish the Bill of Rights.